So welcome everyone to yet another Maine Policy Pours, backed by popular demand. I am your host, Matt Gagnon, for this fine evening. And actually, we're going to go around and do what we typically do here, go around our staff and whatnot. But I think we're not going to take quite as much time as we usually do when we do that kind of thing, because our expert that's joining us here today is not only talking about an incredibly important topic, but happens to have probably more information in his brain than can possibly be downloaded in an hour. So I want to make sure that I give as much time as possible for not only him to talk a little bit, but for us to do some Q&A and try to really pick that brain of his and understand things that are happening in this country a lot better. So just to kick things off here, I want to give a quick update on Maine Policy Institute, the state of things in the state right now, and kind of where we stand in the work we're doing right now. Janet Mills just announced today that they are now extending and growing the outdoor capacity to 100 in the state. So I suppose if you're an optimistic person, that's movement in the right direction, although it's not what New Hampshire's doing, which is completely lifting the cap indoors and outdoors, which they did several weeks ago. But outside of that, there hasn't been an awful lot of movement in terms of policy decisions and changes. They have been sort of marching forward with the reopening plan and the structure of it. Bars remain closed. The plan still is what it is, and there's not much changing from day to day, which is a little bit different than the last time we spoke. When we were talking then, I think that you were learning new information all the time about what the administration was planning in a variety of different areas. And that's not necessarily the case now. We're sort of in a new normal, that obnoxious term you keep hearing. And I think we're going to be in this one for quite some time. The one bit, however, of new information and new news relates to the school reopening plan that the governor announced. Now, what was, I guess, 2 weeks ago? I'm losing track of all days here, but just recently it was announced. The administration and the Department of Education will be doing a system of red light, green light, essentially. They're going to give a classification to Maine counties, either red, yellow, or green, and depending on the magic mix of statistical numbers that the CDC is putting together in whatever proportion they decide is telling them to do which one of those three. They'll be giving recommendations to counties starting, I believe, on the 31st. So we're only a couple days away from that. So look forward to that. I would anticipate, I don't know this, but I am anticipating that likely Cumberland County, York, and Androscoggin County will probably be yellow. I don't know that, but I'm reading the tea leaves that I see, and I think a lot of Maine's counties will in fact be green, but those sort of big population centers that continue to have community spread, I find very likely to be yellow. So what's troubling about that is that will be the starting point, and we're doing quite well in terms of COVID numbers right now. I could recite them all off the top of my head if you want me to, but right now there are 2 people on ventilators in the entire state, and we have, I think, either 12 or 13 people in the hospital, and we've been hovering a little bit above or a little bit below 400 active cases for the last 3 to 4 weeks. So we're in a good spot. So if our starting point with yellow is here, if it gets even marginally worse, and that's in air quotes, I think you're likely to see other communities, Penobscot County perhaps, and others perhaps get yellow. But it's very obvious to me that school districts across the state, even though they are empowered to make their own decisions about this and they do not actually have to take the Department of Education's advice, will be. I got an email myself from my son's school department this morning that spoke of it in terms of requirements. So whether they don't get it or they don't want to get it, they're punting to what the Department of Education is going to be giving them for guidance. So when that happens, that's going to be the next big jumping off point for a lot of discussions about what we're doing and how we're doing it. So that's coming up around the corner, and it highlights, this is the reason we're doing this event today with Tim, it highlights just how important not only the education topic is, but educational choice is for parents, because in unique and bizarre situations like we are currently in, there is no more important time for parents to have options and to be able to make choices for their families, because everybody's going to be a little bit different, and what the public school system is going to be offering to us is going to be in many ways a one-size-fits-all option. So I'm very excited to have Tim Keller with us here today. I'm going to introduce him fully in a minute, but he is one of the nation's foremost experts on the school choice movement and has a wealth of information about some recent Supreme Court decisions and some cases that are in the pipeline right now that you're going to be very interested in hearing about. So I'm really excited to have you here, Tim. Thanks so much for joining us. I really do appreciate it. Now, as this is a happy hour, however, I do want to make sure that I kind of toss things around to the staff and just get a quick update from all of them too, and see what they have for thoughts as well before we get to Tim. So let me kick things off here a little bit with Nick Murray. You are to my left on my screen, Mr. Murray. So policy analyst for the Maine Policy Institute. What is on your mind, sir? What are we working on? What is happening?
Well, Matt, I've been finishing up a pretty long report breaking down the state's response to COVID-19, looking at what data they had available to them versus how they made their decisions, what policies they ended up taking on. And obviously, as a lot of you can imagine, we saw some pretty drastic economic costs to the lockdowns. And given the data that was available in March, this is my findings, there really was not enough to support this sort of drastic wholesale lockdown. Even if you make the case that we still had a lot to learn, we definitely didn't know enough about this in order to make this sort of huge lockdown, shutdown idea, classifying non-essential businesses, driving the state's unemployment through the roof, effectively tripling unemployment for the first couple months. So please be on the lookout for that. I've been working on that a lot the last month or so. So we'll trickle that out a bit and we'll release the full report soon. But that has really consumed a lot of my last couple weeks, Matt. It's been diving through epidemiological studies and unemployment data and all that, but it's been fun. And I'll say it's pretty frustrating to see how our state leaders really got to choose which data they were following, which allowed them to make the choices that they did. It's not like their hands were tied. They had plenty of data showing that it was vulnerable populations, those who are elderly and who had comorbidities that really needed the help. They didn't need to take on the task of planning the entire economy, as we all know, which government abjectly fails at every time it's tried. So that's what we're learning, and we'll be releasing that shortly. So looking forward to it.
Awesome. Thanks a lot, Nick, for the update. And really quickly, I forgot to give something on mine before I go to Jake next. The other topic that's sort of hot in Maine right now, outside of the whole COVID universe, is ranked choice voting. And there's a bunch of stuff happening on ranked choice voting right now. There's a federal lawsuit that has been filed in federal court challenging ranked choice voting in its totality. So there's 4 plaintiffs in that case, 3 Republicans and an independent, and they are basically making the case that they are disenfranchised and their vote is disenfranchised for a variety of reasons. I'm not going to get into that. I can, I guess, do some Q&A later if you want me to explain it in totality to you. But basically the fact that they are forced to make a choice between actually having their vote counted in the end or voting for somebody that they detest is something that disenfranchises them. And it's a good argument. In my opinion, it's far better than the argument that was made when Bruce Poliquin made his initial challenge, which is not Bruce's fault in the least bit. He had about 12 minutes to prepare that thing, and they did the best they could at that moment in time. But this one has had more lead time, more prep time. And I've actually been serving as a consultant on this as well, just giving them as much background as possible because they cited our research on ranked choice voting rather substantially in their filing. So I'm very proud of that, and I'm very proud of the staff for putting that together because it's now serving as a benchmark for a realistic court challenge. I can't promise you that's going to succeed, but I can promise you that it's the best shot you've got in court, and if this one doesn't work, then it's really not going to work, right? There's also the issue of the ranked choice voting referendum questions and the signature gathering effort that the Republican Party engaged in to try to get it on the ballot in November. The Republican Party got in at the very last minute a challenge to the Secretary of State's decision, so there will be, another court case there and more judges looking at that. But understanding it the way that I do in terms of their appeals process and sort of what they've found with some of those signatures and the process, I do think that it's actually a better than average chance that they actually might win that appeal. So I'm not promising that either, but I'm at least cautiously optimistic about their chances of perhaps getting that back on the ballot in November. So those two efforts are ongoing, and it's an evolving conversation, as they say, but there are two things that we're working on significantly, and we're very proud of working on as well. So with that, I've taken up enough of your time. Let's go to Jake really quickly, get his thoughts on a few things. Jake, what's up?
Yeah, in that same vein as ranked choice voting, Matt, something that I've been working on recently, us and 3 other state-based think tanks in the country, us, Alaska Policy Forum, the Freedom Foundation of Minnesota, and the Oklahoma Council of Public Affairs, last week launched Protect My Ballot, which is a nationwide campaign targeting ballot initiatives or legislation throughout the states where they seek to expand the use of ranked choice voting or implement the use of ranked choice voting for their primary and general elections. You can actually go to themainewire.com and read all about that effort, as well as the lawsuit that Matt just talked about. And then there's also an additional article that we just published today. The lawsuit cites a very interesting analysis performed by a Princeton political science professor named Nolan McCarty, who goes through a lot of the cast ballot data in the state of Maine to make his arguments about why RCV is hurting mainly low education voters, elderly voters, and then, as Matt mentioned, also forcing people to rank candidates whom they would not otherwise support to ensure that their ballot does not become exhausted by the final round of tabulation. So go to themainewire.com and check that out. The other thing I would like to apprise everybody of today is that we are running a back to school petition, kind of, transitioning now to today's topic of school and what that's going to look like. We know that for working families, it's going to be incredibly tough for them to resume, business as usual this year if their schools do not reopen. It has major consequences for kids. They won't receive the education they deserve. It could lead to more social isolation and some of the unintended consequences that we have seen as a result of the lockdowns and school closures and other things that have happened over the, the last 4 or 5 months that we've been under single person rule here in the state of Maine. So if you go to mainepolicy.org/back to school, maybe you're a parent, maybe you're a concerned taxpayer, and you want your schools to reopen safely this fall, go to mainepolicy.org/back to school, sign that petition, and then we will be sending those to local school boards and superintendents. So we'll do all that legwork for you.
Thank you, Mr. Posik. Excellent work, of course, as always. Really quickly, tossing things over to Mr. QUATRANO. What's new in your world, sir?
Yes, thank you. I'll try to make this as brief as I can for Mr. Keller. All eyes are always towards Augusta. Today, the Revenue Forecasting Committee said we're going to be $524 million short of our next year's budget, which is $500 million. When COVID kicked in the last quarter of last fiscal year, they were able to save or not spend $106 million. So we're looking at a $418 million shortfall. The governor's talking points is she wants the federal government and this new round of coronavirus relief from the federal government to be able to backfill revenue, backfill their budget. But eventually, even though there's a back and forth between the House and the Senate under what the scope of work will be should they reconvene, the governor can always call them back, and then the scope of work debate is off the table. So all eyes are at Augusta to make sure that they keep it very coronavirus related. There's only 2 ways to get out of this: raising taxes or making cuts. So the governor ain't going to want to go down this road alone, I'm sure. So I'm just keeping our powder dry to make sure that when they get back in there, they're making fiscally responsible decisions up there and keeping us, the taxpayer, in the front of their minds. And I'll leave it there for Mr. Keller. Thanks, everybody.
Something they're known for doing, right? Fiscally decision making. So before we get to Tim, our last update comes from Miss Heather Noyes, who's sitting down there in my third row. Heather, how are you this morning? Got a quick, or this afternoon. What is on your mind, madam?
Thank you, Matt. Hey, it's great to see everyone, and thank you so much for participating today in our event. You know that typically we host a lot of events throughout the year, so I was excited to hear that we can host events here in Maine with up to 100 people. So we've been working feverishly on how can we host our big annual fundraising event. It's in the works, it's in the process, and we hope to be able to give you some really good news about that upcoming event. Today's topic, I'm really excited to hear from Mr. Keller as a mom and a parent of a high schooler. This is one of the most important topics, I think. Being able to provide a realistic and a perfect fit choice for a family and for the child, I think is paramount. So I'm really excited to hear from Mr. Keller, and thank you all for all you do for the Maine Policy Institute and your support and your generosity. And thank you for being with us today, Mr. Keller.
Thanks a lot, Heather. And yes, that kudos and thank you goes out from all of us at Maine Policy Institute to everybody who makes all that we do possible. So thanks so much for that support. Now, without further ado, we are here to hear about a specific topic, and that topic is education. And I'm going to kick things off here with a question about the Supreme Court. But before I do that, I want to make sure that I actually properly introduce our guest today. And that guest is Mr. Tim Keller. He is senior attorney at the Institute for Justice. He leads IJ's educational choice team. In this role, he oversees a talented group of IJ attorneys who help policymakers design constitutionally defensible education choice programs and who defend educational choice programs in courtrooms nationwide. He has served as IJ's lead counsel in Arizona Christian School Tuition Organization versus WIN, a U.S. Supreme Court victory that protected Arizona's pioneering tax credit-funded private school scholarship program. Tim also successfully defended Arizona's Empowerment Scholarship Account program, a publicly funded education savings account program that he helped to design. In his prior role as the managing attorney of IJ's Arizona office, Tim helped protect small businesses from eminent domain abuse and knocked down barriers to entrepreneurship on behalf of eyebrow threaders, African hair braiders, and makeup artists. Tim received his law degree from Arizona State University, and prior to starting law school, Tim worked as a research assistant at the Goldwater Institute, which is one of our sister organizations out in Arizona. After law school, Tim clerked for the Maricopa County Superior Court and the Arizona Court of Appeals. And Tim and his wife, Lisa, have 4 sons. He spends his free time taking care of his family and reading a book a week, which is about how many books I read. So congratulations on that, Tim. Bravo.
Yes, well, thank you.
Real pleasure to welcome you on, Tim. And I know that the big topic that we want to tackle, it's not the only thing we want to talk about, but we do really want to start off things with the Espinoza decision at the Supreme Court level. That obviously was monumental and really important and impactful. And it does have potentially some trickle-down effects for what happens here in Maine and some of our policies here. So I'd love for you to first, for those who don't know too much about the Espinoza decision, actually talk about that case and what went into it and what were the questions it was seeking to decide, what the Supreme Court actually said, and then what does it mean?
All right, well, great. Well, Matt, thanks so much for having me. Thanks for allowing me to visit the great state of Maine from the comfort of my home office here in Arizona. Appreciate the excuse to put on some professional attire, get out of the athleisure wear that I've been in for the last several months. Really appreciate that. So yeah, the Institute for Justice won a truly landmark case in the U.S. Supreme Court in June, a case that, as we will discuss, really should have a direct and real immediate impact in the state of Maine, involving a case that I'm also litigating there. But before we get there, let's talk about what happened in Espinoza versus Montana Department of Revenue. In that case, the U.S. Supreme Court held unequivocally that if a state enacts a school choice program, if it empowers parents to use a scholarship to attend the school of their choice, that states cannot discriminate against the religious options that parents may want to choose. If they have a school choice program, the state must include religious options alongside non-religious options. That's a question that we've been litigating for over 30 years, since the very first modern school choice program was enacted in 1991 to serve low-income students in the city of Milwaukee. We've been battling and wrestling with the question of can a state exclude religious options from educational choice programs? And again, the U.S. Supreme Court in Espinoza answered that question unequivocally. No, the state cannot discriminate against those sort of options. But how did the case arise? It began in 2015 when the Montana legislature created a very modest tax credit funded scholarship program. The way that the program works in Montana is that individuals and businesses could donate up to $150 to a nonprofit organization that would then bundle those donations. The taxpayer would get a $150 tax credit against their income liability. And the nonprofit organization would then again bundle those donations and award scholarships to families based on at least the organization that was first established based on the income level of those families, trying to serve predominantly and primarily students from low-income families and for students who have disabilities. That was the organization's priority. After the program was adopted, the Montana Department of Revenue was tasked with drafting rules to implement the program. And one of the rules that they adopted was a rule that said if a family receives a scholarship, they cannot use that scholarship to attend a religious school. And the Montana Department of Revenue justified that rule based on a provision of the Montana Constitution called a Blaine Amendment. Mr. Blaine, of course, hails from the state of Maine. His probably greatest and most notorious legacy is these particular amendments. I can talk a little bit more about them if you want. There's a fascinating history, but the short version is that at the time Mr. Blaine first proposed similar language to amend the federal Constitution, our then public school system, our nascent public school system, was primarily and predominantly Protestant in orientation. And at the same time that we had this nascent Protestant public school system, there was a huge wave of anti-Catholic immigration. The Catholic, this new Catholic American population found those schools to be inhospitable and started lobbying for a separately funded system of Catholic or parochial schools, or as they were termed at the time, sectarian schools. And Mr. Blaine proposed an amendment to the federal Constitution that would have banned funding for sectarian schools while protecting the Protestant public schools from being so limited. That failed at the federal level, but the similar provisions were adopted all across the country, including in Montana, where there was a provision that basically said that there should be no appropriation of public funds in aid of or for the benefit of sectarian schools. And it was that provision that the Montana Department of Revenue justified its rule. So the Institute for Justice, on behalf of several families in Montana who had applied for scholarships and intended to use them to attend religious schools, challenged the Department of Revenue's rule. And we made 3 allegations. We said, number one, the Montana Department of Revenue has no authority to amend legislation duly enacted by the legislature. It can't pass an administrative rule that conflicts with what the legislature itself said. Number 2, we said the Montana Blaine Amendment doesn't apply on its face for a variety of reasons. Tax credit donations are not an appropriation of public funds, and even if they were, the school choice programs they benefit families, not schools. So just on the plain language of the provision, it shouldn't apply. And then we said, finally, if it does, then the discrimination against religious schools codified in the Montana Blaine Amendment should be unconstitutional under the federal Constitution, because the government should be neutral with regard to matters of religion, neither favoring nor disfavoring religion over non-religion or one religion over another. And so we actually prevailed in the trial court on all 3 grounds, and then we found ourselves immediately in front of the Montana Supreme Court. There's no intermediate court of appeals in the state of Montana, and we prevailed on our first claim. The court agreed that indeed state agencies can't simply amend duly enacted legislation, but they said without that rule, what they were facing was a program that would allow parents to choose religious alongside non-religious educational options, and said that would violate our state Blaine Amendment. And they struck down the entire program after going through what's called a severability analysis and determining there was no way for the court to rewrite the legislation to exclude those religious schools or simply X out language, because the legislature basically said any private school in the state isn't a viable option for the families participating in the program. And so we petitioned the U.S. Supreme Court for review to answer exactly this question. Can a state either exclude religious schools or strike down a program in its entirety simply because it includes religious options alongside non-religious options? And what the court before it did it says, no, the state cannot do that. If the state enacts a program, it must be neutral with regard to religion. And so we are now looking at a rule of law whereby the state must be neutral when it comes to these matters of private choice. And so this is important for a number of reasons. It's important nationwide because there are 37 states that have this sort of blame language in their state constitutions, a number of which have justified those provisions as reasons not to enact educational choice programs to give families additional options outside of the traditional public school system. In our opinion, the Espinoza decision essentially wipes those provisions off the books, at least as applied to the school choice context. And then there are a handful of states that right now that have programs that discriminate against religious options in the provision of an otherwise generally available tuition benefit. And we are either currently challenging those systems or getting ready to challenge those programs. And of course, that's the issue that ultimately leads into the question there in Maine. So that's I think the short version of Espinoza. And hopefully, happy to hear what you have next for me with regard to the question there. But I think it sort of naturally leads into the discussion of Maine. So.
It does indeed. So let me pause here for a moment and just remind our fine viewing audience that if you'd like to submit a question, you'd like to get his thoughts on something, this is a happy hour, friends. So we not only want you to be happy, but we want you to be participating in it too. So if you've got stuff, just send Nick a note on the chat, and we'll go ahead and make sure that we try to get to you as quickly as possible. While you guys are submitting your questions, comments, concerns, and more, I'll go with my next question to Tim, which is about Maine specifically. I know that there's actually some pending and current legislation, or legal decisions coming here in a court case that's sort of in the works right now related to this kind of a question. And of course, what's happening with the Espinoza decision as it relates to Maine is on at least our minds. So if you could just talk for a moment about what it means for Maine and what that sort of court case that is currently in the works is seeking to get a resolution on.
Yep. So in the state of Maine, and actually it's funny, I actually had thought that the ultimate U.S. Supreme Court victory on this issue would come from this case in Maine. This was the vehicle I had anticipated being the one that would go up to the U.S. Supreme Court. I represent 3 families in Maine in a case that's styled Carson v. Makin. As I presume most of the folks on this Zoom meeting know, Maine is a state that is a town tuitioning state. And that can mean a variety of things, but basically, if a town does not operate its own public school system, then that town can have a couple of options. Number one, it can just contract with one particular school to provide the education for all of the town residents, or the town can opt to give parents what we call a tuition benefit, and basically allow families to choose either a neighboring public or private school for the education of their children. But the way that the Maine statute is written, only what the state calls non-sectarian schools may accept the tuition benefit. So, the bottom line is, if you are a family who lives in a tuitioning town, who has a child who is eligible for the tuition benefit, you may not use that tuition benefit at a religious school in the state of Maine. And so IJ, just a few years ago, challenged the exclusion of sectarian options in federal court on behalf of 3 families. It's been a long and complicated history in Maine with regard to IJ and this exclusion of religious schools from your town tuitioning system. Believe it or not, for the first 100 years of town tuitioning in Maine, families were free to use their tuition benefit at religious schools, and frequently and often did. But in 1980, Maine's then Attorney General issued an opinion that said he believed allowing families to choose religious schools would violate the federal Constitution, and particularly the Establishment Clause of the U.S. Constitution. And after that opinion, Maine's tuitioning statutes were rewritten to exclude sectarian schools as options for families, and that was the state of play for about 20 years. In 1999, there was both a state and federal lawsuit filed challenging the exclusion of religious schools. Both of those lawsuits failed. The Institute for Justice litigated one of them in state court. Our friends at the American Center for Law and Justice litigated the other one in federal court. And the U.S. Supreme Court in 1999 declined to review or hear either of those cases. Only 3 years later, in 2002, the U.S. Supreme Court issued another landmark decision called Zellman v. Simmons-Harris. And in Zellman v. Simmons-Harris, the court held that it did not violate the federal Constitution for a state to voluntarily include religious options in a school choice program. That case arose out of Cleveland, Ohio, where again, what we might call a school voucher program had been adopted for low-income minority families in Cleveland, and the state said religious options could be included, and in fact, something like 98% of the families participating voluntarily chose to send their kids to religious schools when they received their vouchers in Cleveland. And the U.S. Supreme Court said in Zellman in 2002, that's constitutional. And as long as the state isn't putting its thumbs on the scale, and as long as parents are exercising a genuine choice as to where they want to send their kids, that including religious options does not violate the Constitution. And then so once we had that decision in hand in 2002, we went back a second time. Again, there were two lawsuits filed, one by the Institute for Justice in state court, another by the ACLJ in federal court. And again, we lost both of those cases post Zellman in the early 2000s. And the U.S. Supreme Court at that time declined to review those decisions. And so that has been the state of play for some time. And then in 2017, there was a different case decided involving religious freedom and religious liberty called Trinity Lutheran Church versus Columbia. And that decision gave us new hope that we could prevail in the state of Maine, or at least drive this issue up to the U.S. Supreme Court to answer the question of whether or not a state can exclude religious options when they give families a genuine choice as to where to send their own kids to school. And in Trinity Lutheran, the court had said that a church could not be excluded from a program that provided state dollars to schools that would resurface their playgrounds using recycled scrap tires, and that it was quote unquote odious to the federal Constitution to discriminate against a church or religious entity simply because it was a religious entity in the context of a generally available benefit program. And so we immediately took that decision in Trinity Lutheran and used it as the basis for what is now Carson v. Makin, and filed that lawsuit in federal court just a couple of years ago. The state trial, or the federal trial court, the district court in Maine, basically said, look, you've got a really strong argument under Trinity Lutheran, but there's a First Circuit Court of Appeals decision, that's the federal circuit where Maine resides, upholding the religious exclusion. And it's really not for me to overturn a higher federal court of appeals. That's their job. And so the court very quickly, basically, I don't want to, punted is the wrong term, but issued a ruling upholding the sectarian exclusion and allowing us to get that issue up in front of the First Circuit very quickly. We actually argued the case in front of the First Circuit in January, arguing that under Trinity Lutheran, the sectarian exclusion should be struck down. The court held the decision, presumably waiting for the decision in Espinoza v. Montana Department of Revenue, which was also argued January of this year. And we got the ruling in June, so I'm anticipating a ruling from the First Circuit very soon. My reading of Espinoza is that the court really has no choice now but to overrule its prior decision and strike down the exclusion of sectarian schools from the town tuitioning system in Maine.
That's awesome. Now let me toss things around to some of the folks in the actual Zoom meeting right now at our virtual happy hour. A couple staff members had questions, and I know a couple of you out there in TV land also had some as well. So keep them coming. Nick is keeping track of these things, and we'll make sure to get to them. Let me start with Mike. I know, Mike, you had a quick question that you wanted to ask, and this relates to Maine itself. So go ahead, Mike. What's on your mind?
Sure. Thanks, Mr. Keller. I was under the assumption that after the Supreme Court ruling, our lawsuit would just be struck down. But apparently our Attorney General off the record says, oh, this is completely different from that, and we need to wait. Can you just kind of explain the court procedures here and how that works? And if they had an argument, what you would anticipate they would argue, if you can even do so. Thank you, sir.
Yeah, no, my pleasure. Thanks, Mike. So after the U.S. Supreme Court's decision, we immediately filed what we would call a notice of supplemental authority and letter brief to the First Circuit. And we said, here's what the U.S. Supreme Court said in Espinoza. Here's our legal challenge to the exclusion of religious schools in Maine. It's pretty clear in our opinion that this means the program should be struck down in its entirety. The Attorney General actually responded to that in the form of another letter brief to the court. And they said, no. Our town tuitioning system isn't a school choice program. What it is it's the provision of a public education. And a public education means an entirely secular education. And so in their response to the court, they said, this is not the provision of a truly genuine choice to parents. We're just paying for public education. And again, they said public education means secular education. And so, we are waiting for the First Circuit to issue its decision. It's been at this point over a month since the U.S. Supreme Court's decision in Espinoza. That's a long time, in my opinion, for the court to wait to issue a decision that seems really obvious at this point. So, we will see what the First Circuit says when it issues its ruling. I hope I don't have to go back up to the U.S. Supreme Court. I'm willing to, absolutely. We drew an interesting panel in Carson in the First Circuit. One of the judges who was on that panel is the author of the prior decisions upholding the exclusion of religious schools from Maine's town tuitioning program. Another one of the judges is former U.S. Supreme Court Justice David Souter. Justice Souter was, of course, a dissenting justice in the Zellman case. And presumably, had he still been on the U.S. Supreme Court, would have been a dissenting justice in Espinoza. And so we know that we drew a tough panel there, but I really don't see a way around the Espinoza decision in the long term for the state of Maine, because what the tuition benefit does for those towns that have decided parents get to choose, it is more or less it's a voucher program for those families. They're the ones who get to decide where they want to use their tuition benefit. They can use it at any nearby public school. They can use it at private non-religious schools, but they cannot use it at a religious school. That is just blatant religious discrimination, and there is no other basis upon which the state has justified that exclusion other than the fact that these schools teach religious values and doctrines, and for that reason alone, they believe those families should not be allowed to use their tuition benefit at the school that they think is going to work best for their kids. So, like I said, I'm happy to go back up to the U.S. Supreme Court, but it would seem to me that this should be an easy implementation for the courts to follow the ruling that we got in Espinoza, it frankly is kind of shocking that the Attorney General just wouldn't have capitulated at that point and recommended to the state that, hey, we need to concede in Carson and we need to just repeal the exclusion of sectarian/religious schools in Maine.
Going from there, let's go around here to some other questions. I know, John REISMAN, you had a question that I wanted to make sure we got to. And where are you? There you are, John. If you'd like to ask it, please unmute yourself if you haven't already done so, and go ahead. Hang on, John, you're not unmuted yet. I think Nick might have to do it.
Just if you could, oh yeah, there you go.
I got
Yeah,
it.
thank you.
There you go.
Go ahead,
There you go,
Nick.
John. Go ahead.
Oh, go ahead, Nick. I don't have it right in front of me, but I think I can So the National Education Association and associated teachers unions are clearly opposing openings around the country. One can speculate on the reasons for that. My question is this, do you think this is going to increase support for school choice? And if so, is there a political leader or interest group that's prepared to leverage that support?
Well, I do believe that it's going to increase support for school choice. I mean, we're already seeing the educational landscape shifting in, I believe, truly seismic and dramatic ways just over the past couple of weeks. Tremendous interest in what, I might have termed or deemed a micro school, which I think other families are calling pods or education co-ops. Families are desperately looking for alternatives to an education system that has closed their doors to those families for quite a while and don't appear to be prepared to open them. Are there groups that are trying to push this forward? I mean, yes. My group, the Institute for Justice, is one of those organizations. At least at the national level, there's a number of them, and Maine Policy Center, I imagine, is one that is really interested in trying to figure out what sort of policy solutions we can implement at the state level. But so like there's REISMAN Foundation, the American Federation for Children, Ed Choice, Excel in Ed. There's just a tremendous amount of groups that are out there really trying to figure out the solutions. And if the schools are going to be open, families should be able to take those education dollars and put it to use right now to make sure that their kids get a good education. It's just a matter of, so many state legislatures are out of session right now. So many state legislatures are facing, terrible budget crises right now. And of course, school choice could be a way to actually help with those budgets, save the state money. But they're just difficult policies to get implemented in this particular environment. And you're right. The defenders of the educational status quo, I think right now are actually quite afraid. They're afraid to open up, but they're afraid not to open up, and they're terrified of what families may create and may find to be a better alternative for their kids. So it's I cannot predict the future, but I think that a year from now we're going to be in a really, really new education paradigm where we've actually got really strong parental interest in new and interesting and dynamic educational options that probably don't look like anything that we really have today. They're not going to just simply be the traditional brick and mortar private schools or charter schools or public schools. They're going to be just a variety of new and interesting options.
All right, Peter Small had a question. This is about state certification. Peter, I just unmuted you, so if you're still out there, go ahead and ask your question.
Hi, yeah. We're a non-state certified Christian school in Bangor. One of the questions our board has had is, does that exclude us from town provisioning if we aren't certified?
So the way, so I presume you're a recognized school.
Yes.
And so yes, the way that the Maine town tuitioning program is set up right now is you have to be an approved school that is also approved for the receipt of public tuition. And so there's two separate levels of approval now under Maine law. There are a couple of paths to becoming an approved school. The easiest, clearest path is to be accredited by the national or the New England Association of Schools and Colleges. And then if an approved school has 60% or more publicly tuitioned students, there are additional obligations imposed by the state of Maine on those approved schools. So that's the way it works now. So in order, assuming that we are successful in striking down the sectarian exclusion, the way the system is set up now, you would have to become an approved school first, and then apply for approval to receive the tuition benefit.
Great, thanks a lot. Let's move on to Jessica Whitworth, who I believe had a question about homeschooling. Jessica, I have unmuted you, so you can go ahead. Oh, hold on, let me try again. There we go. Go ahead, Jessica.
Well,
Yep, I can hear you.
I'm not really sure. We have pretty poor internet, so if I break up, just let me know. I just was curious, if this is something you can use for homeschooling, because I don't really know much about any of it.
Well, thanks for the question, Jessica. My wife and I homeschool our 4 boys. My oldest is actually now in college, so I guess we successfully homeschooled him, and we're working on the other 3. The tuition benefit that exists in Maine right now cannot be used for homeschooling, but there are school choice programs that do allow families to receive a benefit when they do decide to educate their kids at home. For example, the tax credit program that exists in the state of Maine, which operates very similarly to the program that I described in Montana, that program actually allows the scholarship organizations to award modest scholarships to families who are homeschooling for the reimbursement of the purchase of home education supplies. That would include curriculum and other things that families need to educate their kids at home. And then there are also programs that are publicly funded, like the Arizona Empowerment Scholarship Account program that I helped draft and defend out here in Arizona. And the way that program works is that families receive a portion of the dollars that the state would have spent on their student in a public school. So in Arizona, that number is right now about $5,500. And then the parent can control that account, and they can use it for any one of the numbers of options that the state has allowed ESAs to be used for. So in Arizona, if you're an ESA contract student, you do not have to be enrolled in a private school. You do not have to be enrolled in a public school. You are able to use those ESA dollars to purchase curriculum, to hire tutors, to take a single class at a public or private school, to use those classes at community colleges, to even save that money for future college expenses if you don't need to spend all of it, and it can roll over from year to year. And so there are educational choice programs out there that can be designed that would allow homeschool families to participate and really truly tailor and individualize their child's education in a way that's going to work for them.
Nick, I know you had a question as well, so let me go toss things back to the staff here really quick, because Nick Murray's got something on his mind. Nick?
Sure. Thanks, Tim. You mentioned that the Maine Attorney General, and Mike had mentioned this, that they had tried to sort of couch the tuitioning program in the way that it was a public education, and that would put under different constraints. We know how close we were that the Supreme Court could have ruled against Espinoza and kept that sectarian exclusion. I guess I'm thinking kind of the next layer out. How close were we to having courts potentially interpret this law as any public money that flows through an education program or goes to education can be considered public dollars, and then it preempts a lot of these programs because it's no longer a private choice. And so how close were we to having that be the interpretation of courts, and obviously we'd be in a completely different place here, and we're thankful for the breakdown of this court right now, but how close are we to the other side of this coin?
Well, it was a 5-4 decision with what you would consider your traditional conservative liberal split on the court. The liberal justices, however, divided on their reasoning into 3 separate camps. There were 3 dissenting opinions that were written, one by Justice Ginsburg that was also joined by Elena Kagan. And basically what they argued in their dissent was that there was no discrimination here because the state of Montana had simply gotten rid of the entire program, even though the basis for that was discrimination against religion. And so they basically said that we shouldn't have even had standing to be in front of the court, and they just shouldn't have decided the question at all in this particular context, because again, under the way they were viewing it, there was no discrimination amongst religion. Justice Breyer dissented separately and said, hey, this is just a really close call. We shouldn't have any bright line rules. This is sort of for the considered judgment of the court, and in my considered judgment, this would have been fine to have excluded religious schools. And then Justice Sotomayor wrote a third dissenting opinion that would have been like the full-throated bad news opinion that you just described. So at the moment, there was only the one justice who really would have written what I would have considered a truly devastating opinion. And the other justices, would have written something that I certainly wouldn't have been happy with, but would have left us in a situation where we at least would have been able to fight state by state under the individual interpretations of their own state constitutions as to whether or not the religious options could or could not be included, which would have been a better place than had Justice Sotomayor's view prevailed. So we're still in an unfortunately very close situation with that 5-4 court. There are a couple of justices who, we hear rumors all the times about retirements or other things. Justice Thomas is now the second highest ranking member of the court, followed only by the Chief Justice. So he has been on the court the longest at this point. So it's courts are
hanging on by a thread.
Important. I don't want to say we're hanging them on by a thread. I mean, this current court majority, I don't think any of the justices who are in the majority are going to go anywhere of their own accord. We lost Justice Scalia several years ago in a very sudden, shocking, and very sad situation. But I think this current court majority plans to hang on, barring sickness or other tragedy for quite a while. I don't think Justice Thomas plans on going anywhere at the moment, but I don't have any particular inside information there.
Thank you.
We don't have that much time left, so I'm going to run through a couple more questions, and then we're going to wrap things up here. I know, Sean, you had a question. Sean Burke had a question about what other states might be doing and where they might be going on this question. Sean, I don't know if you want to elaborate on that.
Yeah, what state would be the most progressive as far as moving toward school choice?
So the two states that have the most robust school choice environments right now are my home state of Arizona and the state of Florida. Both of those states operate multiple types of school choice programs, both tax credit funded and publicly funded options. They have by far and away the highest number of students. Trailing number 3 would probably be the state of Indiana, who operates a voucher program for low-income students. But in terms of which states right now have probably the best chance of adopting new programs, that would be states like Montana, where we just prevailed. Missouri has been stymied for years because of its state Blaine amendment, and so we've cleared the way there. South Carolina has recently made progress towards adopting school choice, and we're most likely getting ready to defend North Carolina's voucher program from legal attack as well. So, I mean, really, in this particular environment, with if you can harness the energy and outrage that so many parents are feeling, I just think we're living in a brand new reality, and with the right and tenacious approach, the sky's the limit in just about any state. But it's definitely going to take some thoughtful work and some strategic organizing efforts and figuring out what policy solutions are going to work best for the families in each individual state, whether it's vouchers, tax credits, or ESAs.
I like Joe Underwood's comment there about positioning this as a monopoly that needs to be broken up, public school system.
Yeah, I mean, I sometimes, when I'm talking about what is school choice, one of the things I say is that if the government is going to fund education, it ought to do so in a way that really minimizes monopolies and increases opportunities for families to take their education dollars where they want to do it. Yeah. And so, yeah, I mean, the current system is no doubt, essentially a monopoly system.
We don't have any time left except for one more question. I know, Jake, you had one really quickly that you wanted Tim to answer, and then I think we'll wrap things up after that. Go ahead, Mr. Posik.
Yeah, so when you were giving your explanation, Tim, you sounded a little alarmed, I guess I would say, that the First Circuit hasn't delivered that decision yet since Espinoza was decided. So my question is, Are you expecting a decision any day now? Is there a deadline by which they must deliver a decision in that case? Just curious what your thoughts on when we'll actually get the signal anyway.
Well, I've been expecting it any day. I'm still expecting it any day. I really would have thought, when we scheduled this, I would have been talking about that decision. But there is no time limit imposed on the federal judiciary in terms of when they must issue a decision. I actually waited once 3 years for a decision from the Ninth Circuit Court of Appeals in a school choice case. I don't think we'll see that here. I would anticipate that at least in relative terms, we'll get a decision soon, sooner rather than later from the First Circuit. But it seemed to me that, post Espinoza, this was really a no-brainer. A month seems like a long time, considering that we argued the case in January. They must have been working and they must have a draft somewhere. But we'll see. We will see whether it's a couple of days, a couple of weeks, or still a couple months away.
Well, as I'm sure you know, Tim, we could probably keep talking about this for several more hours. So we're not going to do that to you, but we do appreciate you spending an hour with us here in the afternoon. And I want to say a quick thanks to not only Tim for joining us and giving us his expertise and this picture of what the school choice environment looks like now post Espinoza, but also all you participants who were interested in the topic and submitted questions and help us do what we do on a daily basis around here at Maine Policy Institute. Can't possibly say enough of a thank you on behalf of everybody on the team here for all that you guys do as well. So thank you once again, Tim. Thank you, audience. And we look forward once again to another Maine Policy Pours next month. Thanks a lot, guys.